Well, hello, my friends, and welcome to Uncivil Law. I hope you're having a good day. I'm having a good day, and we are here with our latest in the entry of the Tati without a crystal ball as the world turns endeavor, Brown's Saltz extravaganza. Very super exciting as always. We are here today with Saltz's response to Brown's own motion of should I be disqualified, which is a little weird. You don't normally see that with the attorney themselves asking, should I be disqualified? Can I keep presenting on? It's a little weird. There were some reasons there, but strange. And so Saltz today would like to express his comments on this pressing question, which I'd like to remind everyone has little to nothing to do with the actual issue of jurisdiction. I mean, Brown's ability to represent Lorianne is notable, but still not jurisdiction. It's not been jurisdiction for a while. So we're going to continue with things that are not jurisdiction. Again, let's get started with this. Unfortunately, it's a relatively short read. It's only 17 pages today, so I don't have to deal with the drudgery of it going on forever and ever and ever and ever. Ugh. All right, so let's just read these 17 pages and enjoy them for this little bit of a appetizer, I suppose, for maybe this is an in-between course. So it's not really an appetizer because we've already had several meals. So it's like some sort of light in-between course. Whatever. Anyway, so this is plaintiff's response to the defendant's motion to qualify. Oral argument is requested, so we want to have a hearing on this, and we'd like to have argument before the judge about this issue, which again is not jurisdiction. Before defendants have even filed an answer admitting or denying any of the allegations in the complaint, so just by way of a brief aside, an answer here is a procedural step in the lawsuit. So that's a formal step in the process, right? So the first thing that happens is the complaint, and then there's some motion to dismiss sometimes, and then the next thing, and the motion to dismiss, you're fighting about things that are not the merits, right? You can't deal with merits. You can't say that didn't happen. What you say is, if it happened, it doesn't matter, right? In the motion to dismiss. If you say it didn't happen, then you're answering. That's a formal step there. You're saying, no, it's not true. Here's what I admit to. Here's what I deny. Here's some alternative facts, right? So until the answer, you're not supposed to argue facts. You're just supposed to basically argue law, right? Given everything they say, here's why I should win. So the defendants have not filed an answer because up to this point, they haven't denied anything because they can't deny anything because that's how this works at this stage. Okay, so before we even get to the answer stage of this, and how deep are we into this again? I even forget. 50 filings deep into this and we haven't even got to step 2. The attorney Michael Brown and defendants are seeking a blanket order from this court that Mr. Brown and his law firm cannot be disqualified now or ever as counsel in the instant litigation or future proceedings in another forum based on his conduct related to a non-party witness, Lorianne Barnhart. So I don't remember if his motion was quite that expansive about the now or forever thing. It's been a while since we've read it because so many things have happened other than this. But sure, let's say that's something that he asked for, whether or not it would be, now or forever. So yeah, okay. Defendant's motion to qualify should be denied because such a motion is inappropriate. The issue of disqualification is not yet ripe, which is totally fair, because this would only happen if Lorianne needs to testify, presumably, which probably will never happen, because Lorianne's value is to jurisdiction, if even that, and even that I have questions on, as I've expressed before. But I don't see her having any value beyond jurisdiction. She doesn't have really anything to say about the merits, because how could she? She's not a relevant witness as to whether or not defamation occurred or not. We can see the videos for ourselves. So she doesn't have any value, it seems, on the merits. So she probably won't testify ever because it doesn't seem like there's anything for her to offer or testify to once we get past jurisdiction. Defendant's motion to qualify should be denied because it's inappropriate, it's not ripe, discovery is stayed, true enough. The totality of communications between Mr. Brown and Ms. Barnhart is unknown, also true, and requested relief is overly broad. Probably is. Defendants fail to cite any legal standard for motion to qualify, nor they cite a single part case in which a party has been successfully requested such a relief from a court. Well, if it's as broad as Saltz is representing, and again, it's been a while since I've read it, so we'll take his word for it, because Saltz usually is a bit more accurate in terms of his representation of things. Brown tends to go to the extreme ends of the page. Saltz tends to be a little bit more accurate in terms of the faithful recitation of what's happened. So we'll take Saltz's word for it, that he's asking for as much as Saltz says. And then he says, perhaps there exists no such case, which I totally believe there isn't a case like that, because if it's as broad as Saltz is saying, that's asking for a lot. The lack of such case law is likely because, once admitted to the practice before a court, attorneys are not required then affirmatively prove that they are qualified. Yeah, it's a little bit strange, again, for the attorney themselves to say, am I qualified to be a lawyer in this case? Because you've already been admitted to the case, so then you're qualified, absent something else. And so it's a little bit weird for them to turn right around and say, are you sure? Are you sure I'm qualified? Rather, counsel is presumed qualified and eligible to practice until counsel withdraws, which I don't know if Brown wants to do or not, but that's presumably an option, or if the court exercises its duty to examine charges of conflicts of interest brought on a motion to disqualify and determines counsel is disqualified. That sounds right. And he's trying to preempt all that, but yeah. Defendant's counsel, Mr. Brown, has not withdrawn. Maybe he wants to, but no. And no motion to disqualify has yet been filed. Yeah. He's trying to preempt something that doesn't really exist, so saying it's not ripe sounds plausible. Excuse me. On January the 13th, Ms. Barnhart submitted testimony against defendant's interests related to personal jurisdiction, herein the signed declaration, which shows that defendant Katie Joy Paulson misrepresented the nature and scope of defendant's Washington contacts in her declaration filed in support of defendant's motion to dismiss, and establishes defendants have sufficient minimum contacts with Washington for this court to exercise personal jurisdiction over them. Well, the second half of that's more of a legal conclusion rather than a factual conclusion. So you can argue that Barnhart misrepresented her contacts, which, depending on how you read what she wrote, is at least a plausible argument. But whether or not there's sufficient minimum contacts is more debatable. Because, again, that's exactly what we're trying to decide here. So we don't know whether or not defendants have sufficient minimum contacts because the court hasn't told us yet. So that's more of a legal conclusion, but okay. Although it appears from the correspondence between Barnhart and Brown, over 150 emails and 2 telephone calls, that a reasonable person would have had a subjective belief that attorney-client relationship existed, particularly when Brown said, if you want, I will stand for you. That's kind of language of, I want to literally stand up for you as an attorney. So, yeah, that language was pretty problematic for Brown. A determination of Mr. Brown's qualifications to remain as counsel in this matter due to his contact with Barnhart is premature. Right, there is no conflict at this point. Defense motion to dismiss regarding personal jurisdiction is still pending. Yeah. And again, I don't think that Barnhart will pop up in discovery either. I mean, she might, but why? Barnhart doesn't have any value in discovery because she doesn't have anything to offer on the merits. Right? All of the value she has, that seems to me, is for jurisdiction. If you buy it, which I don't, for reasons I've explained. Those reasons primarily being that it was never brought up in the original complaint, the idea of this agency theory. So the idea that Lori Ann Barnhart is a subscriber or has provided financial donations to Katie Joy Paulson, then sure. Yeah, but we could have probably just assumed that in the first instance, which is also why what Katie Joy Paulson was kind of wrote was kind of not advisable, even if on some level technically true, because of course she has subscribers. Of course she has super chatters from Washington. She's too big not to. She's just too big a channel not to. So even if what she wrote was kind of literally true in some sort of technical sense, it was not advisable. So, yeah. But the whole agency theory was never brought up in the original complaint or the original attachments. So, Lori Ann's value is if you want to go down this agency road. And you only want to go down this agency road if you think that it's part of the original complaint, original filings. Now, personally, I think it was tacked on a little too late. That's a personal opinion. And even if it wasn't personally, I'm not really buying the agency theory, because I don't think merely, tell someone this. I don't quite buy the agency theory. I think it's a bit of a reach for me. That's, again, a personal opinion. So I don't really think it was in the original complaint, and I don't really buy it as a legal theory. Nevertheless, of course, as a reminder, I did bump up the odds of Toddy winning, specifically on the basis that the judge would disagree with me. So before the Lori Ann Barnhart declaration, I was predicting 60% for Toddy to win on the personal jurisdiction. So I bumped it up to 65% specifically because I realized that there is a non-zero chance the judge is going to massively disagree with my analysis. I realize that there's a reasonable probability that the judge will think that it's sufficiently alluded to either in the original complaint or its attachments, or that the attachments aren't too late, and they will think the agency is a bigger deal, and they'll think that the agency gets there. So I specifically upped the odds from 60 to 65%, specifically because I recognize the judge could theoretically construct an entire jurisdiction decision around the Lori Ann Barnhart agency. It's not doing that much for me personally, but I recognize the judge could disagree with me. But it only really has value to jurisdiction. After that, it has no jurisdiction because she has nothing to offer on the merits. She didn't, to the best of my knowledge, she didn't appear in any of them. She didn't edit any of them. She didn't publish them. She didn't do anything on the merits of the issue of, are the videos defaming? That's the merits issue. Are the videos defaming? That can be determined from the videos with added commentary from Lori Ann Barnhart about her meaning or intentions, which will be the greatest discovery ever. The deposition will go on forever, trying to go through all those videos in detail. But Lori Ann doesn't seem to have any value, so I don't think she appears in discovery. So there's no conflict, because I don't see a point when Brown would have to cross-examine Lori Ann, because I don't really see her value on the merits, even if she has value on jurisdiction. Okay. Until the pending motion to dismiss is decided, defendants have answered the complaint. It's unknown whether Ms. Barnhart, who's currently a witness on jurisdiction, will be deposed and or a witness at trial subject to cross-examination. That seems a bit unlikely. I don't know what value she could have as a witness. It doesn't appear obvious on the merits. There's no need to inundate this court with a motion to disqualify or qualify counsel that may be needless if the court grants the motion to dismiss. Fair enough, because if they grant the motion to dismiss, presumably this will be refiled, and Brown can choose whether or not to continue proceeding as an attorney. And we'll see whether or not he wants to bail or not. Likewise, until defendants file an answer, until discovery is performed, it's unknown whether Ms. Barnhart has knowledge of any non-jurisdictional issues relevant, such as those will be testifying at trial. That seems a bit unlikely for the reasons I've already said. Lori Ann Barnhart seems to be a very strong former fan of Katie Joy. So her value is as a super duper fan, and ride or die until she wasn't. So she has nothing really to say about the merits. What could she say as either a fact or expert witness about defamation or negligent intention of emotional distress? I mean, unless the only way that she's a fact witness would be if, and this is of course not impossible, would be if she received correspondence from Katie Joy, like through DMs or some other like private means, in which Katie Joy somehow announced her intentions to defame or inflict harm. So that's the only way that she's a relevant fact witness. If Katie Joy had phone conversations or email conversations or instant message conversations or something like that with Lori Ann Barnhart, where she said something that could be understood as an admission that she was defaming or that she was intending to harass them or something like that. So there's a non-zero possibility of that. I guess we have to concede that possibility, that Katie Joy basically confessed at some point to Lori-Ann when they were ride or die. So maybe. But unless that happened, she has no value as a witness. So we'll see here. Excuse me 1 second. All right. Additionally, the court does not have all the facts to affirmatively and indefinitely qualify him as counsel. Although Mr. Brown has provided the court with a compendium of email with Ms. Barnhart, he's not represented to provide the courts with all communications. Fair enough, there might have been in-person or telephone communications or some other kind of communication. To be certain, Ms. Barnhart provided plaintiff's counsel with additional communications that were not included in Mr. Brown's numerous declarations. Okay, we didn't know that. I'm not even sure what those are referring to be honest. Maybe I have forgotten something, but I don't remember. Well, okay, unless Saltz is referring to the instant message, referring to like the Twitter messages and stuff, which she didn't give to Brown based on our understanding, but Saltz did look up. So if he's referring to her Twitter and her DMs and such from Twitter, then okay, but I'm not aware of any other communications beyond that. Neither the court nor plaintiff's counsel can fully evaluate Brown's relationship with Barnhart with all necessary information. True enough, there's not enough information necessarily to know the answer for this, especially if we're looking for it for all of time. There's no question that Mr. Brown now has a conflict of interest regarding Ms. Barnhart. That seems possible, to be sure. The record reflects that Brown has repeatedly attempted to discredit Barnhart's testimony, truthfulness, and mental competency, despite his own efforts to use Barnhart for testimony on behalf of defendants as recently as 2 days before the signed declaration. Yeah, but some things happened after that point, but that might be a conflict. So maybe, at least arguably. So up until the point that 2 days before, there was no conflict between Lori-Ann and Katie Joy. Everything that Lori-Ann was saying to Brown was consistent with what Katie Joy would wish to be true. There was no conflict at that point. So, yeah, up until that point, he wanted to use her because up to that point, she was saying things that were consistent with Katie Joy, which is also, incidentally, why her credibility is suspect, because she made statements. I'm not referring to the declarations here that Brown prepared. I'm not referring to those. I'm referring to things that she said on her own, the emails that she wrote, and the statements she made in the email correspondence. She made statements that are inconsistent with her signed declaration. So there is now reason for Brown to challenge that, because now he has information that makes it challengeable. Finally, defendant's motion to qualify relies on hearsay evidence. Brown's correspondence with Barnhart and Brown's correspondence with purported relatives of Barnhart. Yeah, kind of, sort of. I mean, it is hearsay. It is hearsay, but it's also, as we were pointing out, it's the stuff that Barnhart herself wrote, not the declarations Brown prepared, but the statements that she herself wrote. If hearsay, it's still impeaching, because you can impeach, which is the technical term here, to challenge someone's credibility. You can challenge someone's credibility based on things they've said in other contexts. And there may or may not be explanations for that that'll be satisfactory. But yeah, you can basically use a person's own words against them to show that they're unreliable or otherwise. So, in light of these issues, plaintiffs were not and are not in a position to stipulate to Brown's request to retroactively remedy his conflicts with former client. For the same reasons, the court should deny motions to qualify. Again, maybe my memory is slightly failing me here, but what I seem to remember that Brown asked of Saltz, and what I think he asked of the court, was only that given what they knew at that time, they would agree that he shouldn't be disqualified. So As memory serves, Brown wasn't saying for all of time, no matter what you learn. Brown was asking Saltz and his team to agree that based on what they knew at that time, they shouldn't disqualify, which maybe they can't commit to, but it's not quite the same thing as saying for all of time. So I seem to recall that's what Saltz asked of, what Brown asked of Saltz. And I don't quite remember if that's what Brown asked of the court, but I think so. And there were 2 questions in chat that I want to answer. Grace Case asks, I know you're only speculating with this answer, but what do you keep the judge's ruling from issue this far? Busy docket, truly complicated, or extraneous filings? Hard to say. Of course, the extraneous filings aren't probably helping. The judge could choose to ignore them and get to the issue at hand, but that depends how the judge likes to do their workflow, and it depends on a whole host of other issues, and maybe the judge is busy with other things or a whole bunch of issues. I don't think the jurisdiction issue is super complicated, but then again, I haven't looked into the deep depths of jurisdiction on this, so maybe it's more complicated than it appears. But I'm not sure what is keeping the judge up. Maybe it's the extraneous filings is as good a reason as any. Nate the lawyer says witnesses can switch sides, lawyers cannot. Yeah, fair enough. Bird Alert says, can it still be considered hearsay unless Laurie is being cross-examined? How much do facts deter Toddy as the non-moving side played in the Lorianne's signed statement? Well, when you're talking about hearsay from someone testifying on the stand, if it's from a party opponent, it's non-hearsay. It's not even hearsay at all if it's from a party opponent. So if it were Lorianne testifying, if it was Katie Joy Paulson testifying, and you were contradicting her based on her own statements, then it's not even hearsay at all. So you don't even have to worry about that problem. Of course, Lorianne is not a party, so you can't say it's not hearsay. And therefore, you have to say it comes in for some other reason, which you can do, because in order for the hearsay rule to apply, it has to be an it has to be an out-of-court statement that is offered for the truth of the matter asserted. And here is where you get to play one of those wonderful technical games as a lawyer. Because in this situation, you wouldn't be offering it for the truth. You'd be offering it merely to challenge the credibility of the witness. So you're not offering it saying, this statement she made is true. You're offering it to say, this statement contradicts with a statement you swore under oath, which is not the same thing. You're not saying that the statement is in fact true. You're simply saying that there's a contradiction, and that is a distinction with a difference, right? So for the hearsay rule to apply, it has to be out-of-court statement offered for the truth. So here, the statements would be out of court, but they're not being offered for their truth. They're being merely offered to contradict the veracity and credibility of the witness, which is a distinction that is worthy of mention. So the hearsay rule does not apply for that reason. I'm asking if Lorianne's emails and unsigned statements are hearsay until she's being cross-examined. Same analysis would be the same answer. Yes, they're hearsay. It's just that the hearsay rule doesn't apply because you're not offering them for their truth. You wouldn't be offering them for their truth now. You're not saying the statements that she gave to Brown are true, or you're not arguing that they are true. You're merely arguing they contradict her sworn affidavit, and therefore her credibility is damaged, which is not the same thing. So I don't think the hearsay rule applies for that reason. So these are the wonderful distinctions you get around, and thank you for the questions. Okay, so let's clarify some facts. Facts are always good. Communications between Lorianne Barnhart and Mr. Brown. Okay. Beginning on December the 24th of 2020, Mr. Brown and Miss Barnhart proceeded to exchange nearly 150 emails and 2 short phone calls over the course of 18 days. None of these communications established that Brown advised Barnhart in writing that he did not represent her or was not providing legal advice. This is pretty true. There is at best one email that somewhat obliquely could be read if you were squinting as saying, I'm not representing you, but was far from clear and far from sufficient to put a reasonable person in that frame of mind. You're having to reach, and if you're having to reach, you have problems. The nature of the approximately 150 emails that have been produced by Brown reveal they provided Barnhart with legal advice relating to alleged harassment she received on Twitter following the filing of the declaration, maybe, how she should respond to the proposed subpoena, much more clearly legal advice, and her proposed testimony, which is also more clearly legal advice. Additionally, the primary reason Barnhart contacted Brown was to solicit her service to correct the record as to her employment, which he could have done without really representing her. He could have just merely contacted him, but he tried to get cute for reasons that he thought would be to his advantage, and maybe that was the right decision at the time, but that decision may come back to bite him in the end. So, In the signed Barnhart declaration, Barnhart testified that Brown offered to represent her as a third-party witness in litigation. Yeah, I'm not sure he exactly offered strictly, but it would be reasonable for her to perceive it. And that's all that matters in the end under the legal standards that here. She has to be able to subjectively come to the conclusion that that's true. And so, Ms. Barnhart also advised Plaintiff's counsel on the 12th. She believed Brown was acting as her attorney because she repeatedly asked him for legal advice, which he provided. And he offered on multiple occasions at no cost. Yeah, I'm pretty sold. I'm pretty sold on the proposition at this point that Brown was representing Lori Ann, because the standard that is applicable in Washington, at least, and I can't speak to the standard everywhere, so this may not be the standard everywhere, but the standard in Washington is whether or not the client, or the purported client could reasonably subjectively believe it. Could a person in Barnhart's position reasonably believe it? And the answer would be yeah, very much so. She could draw that conclusion pretty easily, because Brown did basically nothing overt to dissuade that belief. And he did a lot of things that would foster that belief. So he was at best sloppy, and unfortunately sloppiness is going to hurt him here. Brown also dissuaded Barnhart from contacting plaintiff's counsels directly. For example, Brown wrote, "I spoke with Saltz today. They're planning to subpoena your Twitter account because they see you closed your account and think there might be evidence there about your connection to Katie. I did not disclose that you and I are in touch. Saltz even complained to me that you threatened him via DM." And then Barnhart says, "Figures, what are your thoughts?" Barnhart apologizes. Brown says, "I have to think about this. For the time being, it's best for you not to make any contact with Katie and vice versa." Which is probably just good advice universally, but still legal advice. So probably good advice from any competent attorney, but the fact that it came from this particular attorney might be a problem for Brown. They're working hard to paint you two as a team, and that's not good for either one of you. Probably true. Yeah. Barnhart responded in relevant part. "Maybe it'd be just easier if I met and went with Saltz myself. He can see me face to face and see I'm no threat and nothing to hide. I actually present myself very well. We'll debate the truth of that statement another time. I know how to be professional when I need to be. Don't worry, I'll not say anything without telling you first." And Brown says, "I understand that impulse, but you need to understand the type of person he is. Do you have the ability to pay for your own lawyer to help you if they do issue a subpoena?" So, yeah, see, these are the kind of oblique statements that might suggest potentially that Brown isn't representing her, right? Because do you have the money to pay for a lawyer could be read to suggest, in isolation, I am not your lawyer. Unfortunately, there were many, many, many other emails that said many, many, many other things. And this is kind of oblique. It's not direct. It's not saying, I do not represent you. Do you have money for your own lawyer? It's just saying, do you have money for your own lawyer? Potentially me. So even if she's not a client, she's a prospective client, which might be just as good as far as the rules are concerned. So it may not matter either way. Attorneys do have duties of confidence even to prospective clients once that prospective client relationship is established. So, there can be that, sure. It's unclear if Ms. Barnhart responded to the above emails. The record is devoid of a response. Yet, Brown wrote, "You'll get a copy of the subpoena if they issue it. If it asks for communications with Katie, it sounds like there won't be too much of it. It's too broad. You can challenge it," which is correct. Good legal advice, but legal advice nevertheless. Right. You can challenge a subpoena for any number of reasons. Overbreadth would be a valid reason. So yeah, You could do that. Good legal advice, but legal advice nevertheless. Brown also convinced Barnhart at least one occasion she did not need to consult with separate counsel. Barnhart wrote, I used to volunteer for Snohomish County Legal Services. Maybe they can help me. Brown responded, what help do you think you'll need from legal services? Barnhart writes, advice. Uh-oh. What help do you think you'll need from legal service? I might need legal advice. Uh-oh. And Brown at this point responds, that's good. I've been helping you on a really informal basis, but I can't give you legal advice because I'm not your attorney. Perhaps you should seek alternative counsel. No, Brown didn't write that. Instead, what Brown wrote is, I understand. You really have nothing to worry about with this. You've done nothing wrong. I think I can help you with the response for no charge. It's very simple. See, this is the kind of statement that could read as to a reasonable observer, as to a reasonable client, that maybe you're their lawyer. See, these are the kind of statements that could be understood as I am representing you. I am your lawyer, along with I will stand with you, along with other statements. So could Barnhart draw the reasonable conclusion that Brown was representing her? Yeah. So, in Washington at least, that's enough. So, there were some questions. Melissa of the Night says, I look nice. Well, thank you very much. Raymond Eugene says, if the court finds Lori-Ann and Brown had formed an attorney-client relationship, could Lori seek retribution for Brown for disclosing their emails? Disclosing clients' emails sound bad. Well, Brown is trying to squeeze the disclosing of the emails within an ethics rule. And he cited this ethics rule in previous filings. And there's an ethics rule that allows an attorney to disclose confidential and privileged matters if it's necessary for the purposes of the lawyer defending himself. So the rule isn't written this way, but it's contemplated to be for malpractice. So if you sue me for malpractice, and I can show from confidential communications not so much, then I can disclose the confidential communications to show not so much, that I'm actually a good lawyer. So Brown is trying to disclose, squeezing all these things into this rule because Lori-Ann in the declaration accused of being a bad lawyer. And so he's like, no, I'm not. Here's every email I ever wrote. So he may or may not fall within the guides of that ethics rule, because usually when you are disclosing things under this ethics rule, you generally have an obligation to try to mitigate it and try to keep it minimal and try not to expose it to the world. So Brown could have presumably filed all these things under seal, and because the only one he's being charged with at this point is to the court, or theoretically, or that's the only one who would have an interest in this at this point. So presumably he could have satisfied the ethics rule by disclosing things only to the court under seal, or he could have disclosed fewer things. So it could be argued that there might be a violation of the ethics rule, because it may be that he didn't have to disclose it the way he did, or he disclosed more than was strictly speaking necessary. So there may be some problems there too, but he's trying to squeeze it within an ethics rule that allows a lawyer to disclose confidential communications for the purposes of defending oneself. So, we can debate that at another time, but yeah. Gossip with Graham says, if you wrote a document for her to sign, wouldn't that prove he was her attorney? It goes a long way to helping. Yeah, it goes a long way to helping. Here is a declaration that you could sign, and I could file for you. Yeah, that could be the kind of thing. I have prepared a declaration for you to sign that will be filed in court. And you could sign this, and then I will file for you. That could be the kind of thing that a reasonable person could perceive as an act of an attorney. That does not help Brown's cause, no. Yeah, and Marissa says, if Lori-Ann generally thought she was wrapped, does she have a case? We discussed that. Ethics rule, maybe, debatable. Chelsea Dicey says, can judges issue a response if they deny sanctions? Oh, sure. Yeah. Is this something court could hold Brown in contempt for? No, it's not contempt. He hasn't done anything in contempt. No, I don't see this. Maybe other things. There might be other things in the case that are contemptuous, but not this, no. AKA, how does contempt work? It applies. I don't think it applies to this. There's some other things that might be contemptuous depending on your point of view. For example, during the one hearing they had on the record, Brown said, let me recite to you this declaration verbatim. And what he then said was not the declaration verbatim. So that could be viewed as contempt. His defying various orders of the court, such as line numbering and filing things, could be viewed as contempt. So there's some other things that could be potentially contemptuous depending on your frame of reference. I don't see any contempt here, but there may be other problems elsewhere. But thank you for the questions. Around January the 11th, Barnhart terminated the attorney-client relationship. Yeah. And then on the 13th, the signed declaration was filed. That's pretty accurate, yes. On January the 22nd, Brown filed a supplemental declaration in support of the motion to dismiss, in which he purports to characterize his communications with Barnhart and accuses Barnhart of filing false statements under penalty of perjury, which was a reasonable thing for Brown to do at that time based on what he knew. Because he obviously at the time did not know the nature of his communications. He did not know the nature of Lori Ann's communications with Saltz, because how could he? What he did know is that the declaration massively contradicted statements that Lori Ann had said to him, including in writing. So saying, these statements look like they're false was a pretty reasonable thing for Brown to think at that time. Mr. Brown also attached the relevant emails with Barnhart, nearly 200 pages, for public review and consumption, which might violate the ethics rules. So, there could be a problem there, maybe. Potentially. Could be more than is necessary to solve the problem. Mr. Brown withheld those containing especially sensitive health information, well, good for that, I guess, and purported to provide all such communications in his second supplemental declaration. It remains unclear whether all the communications have been provided, which is fair enough because there could be communications other than these emails, including other emails, instant messages, DMs, phone calls, whatever, in-person interviews, whatever. So, yeah. Just move this out of the way. Great. Argument. Defense again rely on hearsay evidence and 3 unsigned declarations prepared by Brown. Yes, it is hearsay. Now, the unsigned declarations are valueless because Brown prepared them. So those have no value. The statements that Lori Ann herself wrote have impeachment value because they're not hearsay because they're not being offered for their truth value. Or that's how I see it. Plaintiffs previously moved to strike the evidence in the opposition for sanctions pursuant to local rules and some other stuff. Plaintiffs reiterate their motion to strike. Okay. Although practicing attorneys in the Western District of Washington must abide by the rules of professional conduct as promulgated and interpreted by the Washington Supreme Court. Sure. The court retains responsibility for controlling the conduct of lawyers practicing before it. Very much true. The court gets to control whatever's happening in its domain for as long as it's happening. It's one of those inherent things. Non-client litigants may, under proper circumstances, bring motions to disqualify counsel based on conflicts of interest when ethical changes of sides was manifest and glaring, or an open and office ethical violation which compels the court its duty to act. So the Saltz is suggesting that perhaps maybe there could be a motion in the future, but it's not there right now, so, deal with that stuff. While a motion to disqualify ultimately may be necessary and or prudent, defendant's instant motion to qualify is premature as well as improper, and the requested relief that the court enter an order finding no grounds exist is overbroad. Is that exactly what was written? I forget exactly, but okay. Defendant's efforts to preemptively obtain a ruling on disqualification due to alleged concerns of this being a litigation tactic are misguided and failed to show ripeness. Maybe less on the misguided, but more on the ripeness, I agree. Contrary to the assertions, defendants are not being forced to proceed under constant threat. They'll choose at some strategic time. Okay. Rather, it's Mr. Brown's actions that have created the situation which defendants find themselves, and it's defendants' motion to dismiss and their agreement to stay discovery that make the disqualification issue not ripe. Well, that's kind of true, kind of not. So defendants might be forced under this threat due to defendants' self-own. So I don't know that I completely agree that defendants are not being forced to proceed. They are being forced to proceed because defendant done owned themselves, or defendant's counsel to be more precise. So, that's a self-fail on that one. It probably looked pretty good initially. Maybe it was pretty good initially, and it kind of all blew up in Brown's face. So maybe Brown couldn't have seen that one coming. Maybe none of us could, but it didn't work out in the end. So maybe there's a cautionary tale for all of us lawyers everywhere. Beware Trojan horses, and think about how they might kick back on you, I guess. I'm not saying that Lorianne was a Trojan horse. I'm just simply saying that maybe it's too good to be true, is my point. Something along those lines. Anyways. Moreover, Washington law prohibits the use of motions to disqualify as litigation tactics. True enough. Yeah, you can't do that. A motion to disqualify must be filed with reasonable promptness after a party discovers a basis for a conflict, and its failure to do so could result in waiver. That's also true. Yeah, so if Saltz waits too long for the right moment, it could be denied because Saltz waited too long for the right moment. Right, so that would be an example of Saltz potentially doing a self-own. Delaying and filing a motion to disqualify is suggestive of its use, purely tactical purpose, and could be the sole grounds of denying the motion, which is an interesting argument for Saltz to put. And maybe this is what Brown's master strategy was. If we think that Brown is doing some 3D chess in his head, so how much credit do we want to give Brown here is the operative question for the moment. So maybe Brown was hoping that Saltz would write exactly this, because maybe he was hoping that Saltz would write, if someone delays too long, that could be grounds, and then at some point in the future, if Saltz were to move, he can say, "Hey, you waited too long because you had the opportunity. It's wavered." So, how clever do you think Brown is the operative question of the moment, or do you think that Brown just lucked into it? So do you think Brown was playing some 360-degree underwater hungry hippos and filed this motion specifically hoping for Saltz to write this so that one day he could point to it? Or did he just back-end his way into it being lucky? Because maybe this was the whole purpose all along. Or maybe he's just going to get fortunate that someday maybe he can point to it and say, "Aha, you recognize that if you don't use it, you lose it. And it's far too late now. You could have brought it up before because you were obviously aware of everything. In fact, I told you should be aware. I put the knowledge specifically in your head. And even with all that knowledge, you defied the issue. So it's too late now. Ha 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 ha." Maybe this was some 360-degree underwater hungry hippos, and Brown is truly the genius the whole time. I don't know. Maybe that's what he was going for. I don't know. Here, plaintiffs have delayed filing a motion to disqualify because the disqualification issue is not yet ripe. So they're saying it's not yet ripe. But then, of course, Brown could say, yes, it is, because, well, what might be the standard for ripeness? What might be the standard for ripeness, right? Well, a standard for ripeness might be that a motion to disqualify must be filed with reasonable promptness after a party discovers the basis for an alleged conflict. So presumably, Saltz has discovered the basis for a conflict. Now, maybe it's ripe, maybe it's not. Because maybe it's not ripe because Lorianne is not yet a witness, and so maybe the conflict is too speculative. Or maybe it is ripe because Saltz knows everything that he needs to know, and maybe it's not too speculative. So is it ripe or is it not? That could be a fight later, but maybe Brown was trying to give himself this extra edge for that fight someday. Plaintiffs first became aware of this issue on January the 12th, which was after defense motion to dismiss. Sure, fair enough. Depending on the court's ruling to dismiss defense litigation decision, where defense continued to pursue a jurisdiction defense, and on what basis the defense put the issue in their anticipated answer, assuming they file an answer, which I guess strictly speaking they don't have to, right? They could choose not to file an answer and go right for a motion for summary judgment, I guess. That's possible too. You can skip steps. Mr. Brown's qualification or disqualification as counsel may be rendered as moot. So maybe it's not ripe. Maybe it's not ripe. Or maybe it is ripe. Maybe Brown is just trying to give himself that out. I gave you the information. I put it actively in your head. And you still didn't use it. Additionally, discovery has been stayed in this matter until the court rules on the motion to dismiss. And until discovery is conducted, plaintiff cannot ascertain whether Ms. Bownhart would be testifying witness regarding jurisdictional and or non-jurisdictional facts. Well, once the motion for jurisdiction is decided, why would she testify about jurisdictional issues? And yeah, so I don't see that happening. And what non-jurisdictional facts could she offer unless Katie Joy Paulson said some incriminating things to Lorianne, which is definitely possible. Or whether Mr. Brown is in possession of proper written conflict waiver signed by defense. There's no way he has a conflict waiver. There is no way on this earth he has a conflict waiver. Therefore, disqualification is not yet ripe for consideration. And good luck getting one now, by the way. In addition, even if the disqualification issue was ripe for consideration, a delay of less than 3 months while discovery has been stayed and no substantive motion practice has been incurred. Yeah, we have not dealt with anything substantive. We have not been on the merits. We have yet to do anything substantive at all. This has been going on for so long and not a drop of substance to be found, man. We have not touched the merits of this thing yet. Can occur until the court rules on the pending motion to dismiss, is not unreasonable nor grounds to deny motion to disqualify. Yeah, Saltz might be right legally. He might very well be right legally that the motion to disqualify is not yet ripe. So he may have the better end of the argument. He probably does have the better end of the argument. I'll give an opinion. He probably does have the better end of the argument. It probably is not ripe until the conflict is actually manifest, and it's not manifest for all the reasons Saltz said. So yeah, I'll give an opinion. Yeah, I think Saltz is probably right. He's probably right that it's not yet ripe. Good for Saltz. And yeah, Brown, maybe Brown was trying to get somewhere and he won't actually ever be able to get there. Maybe he realized he screwed up. Yeah, maybe this is what happened. Maybe he realized he screwed up. And he thought, 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 how can I fix it? As lawyers do. That's one of the things lawyers do with their time. I have a problem, how do I fix it? So Brown, presumably, realized he had a problem. Because Lorianne filed this thing, and he realizes that there's a potential conflict issue looming. Uh-oh. So maybe Brown put his thinking cap on, and he thought really, really hard. And he's like, how can I solve the problem? And what he dreamed up as the way to solve the problem was a motion to disqualify that he'd file for two reasons. One, to give Saltz specific knowledge of the issue, and two, that he could argue, hey, you had everything you needed and you didn't take advantage of it, so it's too late now. So he's trying maybe to fix the problem. I think Saltz has the better end of it, though. He won't be able to fix the problem because I think Saltz is right that it's not ripe. But Brown was trying. So if that's what happened, we'll give Brown points for creativity, even though it doesn't really solve the problem in the end of the day. There were a couple more questions. How much did this cost Toddy? You mean, did this filing cost Toddy? I don't know. Is individual filing? Probably not very much. I mean, it's not super long, so. Let's see, what are they getting charged there? Well, we don't know what Toddy's bills are. We don't know how much she's getting paid, right? Brown's getting $450 an hour. So let's say Saltz is charging $500 an hour as a rough estimate. So now we have to figure out how many hours this was. Probably $3,000 as a reasonable guess, maybe. And then Abi says, think of this as an amuse-bouche. Yeah, or a palate cleanser or something like that. Very fair enough. Okay, so what is the standard for an attorney-client relationship, at least in Washington? Let's figure that out. An attorney-client relationship exists when the conduct between an individual and an attorney is such that the individual subjectively believes it exists. Now, that subjective belief probably has to be reasonable. But, as we've discussed, yeah, we're there. The client's subjective belief, however, does not control unless it's reasonably formed. Okay, they just said what I literally just said, except they let me move this thing so Brown bears a little easier to see. Yeah, so they said exactly what I said. Yeah, so it's subjective, but at least it has to be reasonable. It is. A court must have facts of what actually occurred between the two parties in order to determine the legal question. The legal question would be yes, as to the attorney-client relationship. An attorney-client relationship may be implied from the parties' conduct. It need not be memorialized in writing. Yeah. Washington courts have even held that a short consultation may create an attorney-client relationship. It's possible, or even perhaps more to the point, a prospective relationship. Yes, it can. So you have to be careful about that. If you're having someone talk to you, right? You have to be careful sometimes. Here, Ms. Barnhart testified that she had an attorney-client relationship with Brown. Defendants even sought sanctions against plaintiff for violating Rule 4.2 when they spoke with Ms. Barnhart. Plaintiff, Mr. Brown, advised the court on more than one occasion that he and Ms. Brown exchanged nearly 150 emails and 2 phone calls over the course of 18 days. I'm not sure the exact precise number really matters that much, but whatever the number was, it was a lot. While Mr. Brown only cites 2 emails to and from Barnhart in the instant motion to qualify, the breadth and nature of the available correspondence as a whole appears to support Barnhart's reasonable belief. For example, the available correspondence shows that Barnhart repeatedly requests Brown's legal advice, and as early as December of 31, told Brown that she would not do or say anything without telling him first. Brown repeatedly offered legal advice. Brown actively dissuaded them from contacting plaintiff's counsel. Barnhart indicated to Brown at least 4 occasions she was inclined. However, Brown convinced them not to do so. And also literally said, if you're willing, I will stand for you, which is kind of what did it for me. That was the one that was the straw that broke this camel's back. When we saw, I will stand for you, I'm like, that did it. That was the one that does it for me. I'm done. Based on the preceding examples, Barnhart's subjective belief, attorney-client relationship appears to be reasonably formed. Barnhart terminated their relationship. Yep. Sounds right to me. Even assuming Brown and Barnhart did not have an attorney-client relationship, Barnhart appears to at least be a prospective client. Yeah, fair enough. Maybe they weren't attorney-client. Does it really matter? Probably not. Because prospective relationships, right? Okay, Rule 1.18 of the Washington rules, and every state has a rule similar to this, but this is Washington's version of it, which establishes the duties owed to a prospective client, at least in Washington, is the applicable rule. That rule provides the following things, and this rule will be similar to most states, although not necessarily identical. A person who consults with a lawyer about the possibility of forming a lawyer-client relationship is a prospective client. Even where no relationship ensues, a lawyer who learned information from a prospective client shall not use or reveal that information except as Rule 1.9 would permit. And we discussed that before. A lawyer subject to paragraph B shall not represent a client with interests materially adverse to those of a prospective client in the same or substantially related matter, if the lawyer received information from the prospective client that could be significantly harmful to the person in that matter. So, that's probably on point, yes. The commentary to the rule provides the following things. Whether communications, including written, oral, or electronic, constitutes consultation depends on the circumstances. The answer to every legal question is it depends. You guys know that. For example, consultation is likely to occur if a lawyer, either in person or through lawyer's communication in any medium, specifically requests or invites the submission of information about potential relationship without clear and reasonably understandable warning and cautionary statements that limits the obligation. Right? Which is why my descriptions of my video say that, this is just general legal education, not for a specific case, because I can't provide any information for specific cases for exactly this reason. And if a person provides information in response. In contrast, consultation does not occur if a person provides information to a lawyer in response to a communication that merely describes the lawyer's education, experience, areas of practice, and contact information, or provides legal information of general interest. That would be me. right? That would be me. I'm providing legal education of general interest. So yeah, if you provide me information, that is not an attorney-client relationship because I'm merely providing legal information of general interest. So yay, I'm covered by that too. It's always nice to have coverage. Here, Mr. Brown and Barnhart exchanged nearly 150 emails over the course of 18 days. At no time has Brown submitted this court evidence or argument that sent an email to Barnhart that contained in clearly and reasonable understandable warnings and cautionary statements that limited the obligations to Barnhart. Instead, Brown made numerous requests and repeatedly invited Miss Barnhart to submit information about herself and the matters at hand. Miss Barnhart disclosed substantive and confidential information to Brown that could significantly harm her. The information may be largely out in the open, so it might also moot the issue for that reason. And the rule as written doesn't expressly contemplate this because it wouldn't normally come up. But I guess it's arguable that because all the information that he got is now out in the open, that the conflict is mooted. I mean, I guess you could argue it. I don't know how that would work out. I don't know if there's any case law on that or not. You could try. Mr. Brown may be barred from using these confidences against her. Yeah, but all those confidences are now in the open, so question mark, question mark, question mark. Who have an adverse interest in the same matter. They may or may not have an adverse interest in the same matter because Barnhart may not have an interest in the matter. She doesn't have any interest in the outcome, so that's debatable too. At least arguable. While plaintiffs have not yet moved to disqualify Brown as law firm due to disqualification, it appears a conflict of interest exists, such that the motion to qualify must be denied. Brown asserts his communications were for two purposes: to explain the abusiveness of the Fulmer Declaration and to confirm defendant's statements that they did not know Barnhart resided in Washington. However, Barnhart's testimony states, among other things, the Fulmer Declaration was accurate, with the exception of where Barnhart allegedly worked. Paulson did, in fact, have reason to know that Barnhart resided in Washington by April 2020, if not earlier. And defendant Paulson misrepresented the nature and scope of the contacts in her declaration. Notably, Barnhart's testimony centers on the same issue. Brown admits were the subject of former representation, and her testimony is not favorable to Brown or his current clients. That's true. In fact, Mr. Brown alleges that Barnhart's testimony and signed declaration changed the first story she told him by 180 degrees. That's kind of true, yes. That's more objectively correct, yes. The story that Barnhart told Brown, the story that she swore to, are kind of in conflict, yes. That Brown contends that Barnhart is now the opposite position is enough to establish adversity. Well, an adversity between Brown and Barnhart, sure. The crux of an adversary inquiry lies on a lawyer's duty of loyalty. Parties are allowed to switch sides, lawyers are not. Fair enough. But then again, Barnhart isn't a party exactly, is she? The underlying question is whether the lawyer was so involved in the matter, in the substantive representation, can be justly regarded as changing side in the matter. And there's also this potential issue of mootness that's lurking around because of the bizarre world that we're in. Because everything that was confidential has ceased to be confidential, so I don't know if there's anything left. So there's that too. Not only is Barnhart's testimony unfavorable for the defendants and Brown, but also nearly every one of defendants' filings, defendants and Brown, have attempted to use the communications with Brown to disqualify her or discredit her, which is fair because, as to the substance of it, whether or not it's fair for Brown to do it is a debatable question, but it's fair in the abstract because the statements are in conflict. Whether it's fair for Brown, questionable, because of the reasons and duties of loyalty and the things we've discussed. Accusing her of submitting false statements, at the time he made that, there was some evidence to suggest that, whether it should be coming from Brown is a problem, and or alleged she did not have the capability to execute it, which might also be possible depending on the information that was available to Brown in terms of her psychiatric or medical state, which that much at least has not been exposed. But is information that's presumably available to Saltz and his team. So, I'm not sure. And might be discoverable if it wasn't. So there might be some questions in here somewhere. But yeah, Brown could have learned information that would make him think that, for example, just to say something at random, I don't know if this is true, but it could lead him to the conclusion that, say, for example, Barnhart is unusually susceptible, and because Brown had more time, he was able to have more confidence, and because Saltz acted so fast, I mean, even Saltz says he acted fast, right? Saltz says that Barnhart fired Brown on the 11th, and they filed the declaration on the 13th. Now, Saltz is given a whole bunch of things that show that, from his point of view, that looks good. But Brown is able to make the contra-argument, that maybe she was, there wasn't enough time to vet, and maybe there's some reason he knows that or whatever, but yeah. So it's possible, it's at least theoretically possible for Brown to have his cake and eat it too. Because I had so much more time, because I had so much more communications, I was in a position to overcome whatever problem there was, and you weren't. So maybe. Not to say it is true, but maybe there's something there somewhere. Moreover, if and when this case proceeds, Mr. Brown may need to cross-examine in deposition or trial Barnhart about these exact same issues, including issues raised in confidence during the attorney-client relationship for the sole purpose of trying to create doubt as to whether Barnhart gave truthful testimony and or is a competent witness. He might not need to do that, though, because there might be enough information in the open for him not to have to cross-examine it. He can offer it through some other mechanism. He can offer it through impeachment, which is technical cross-examination, though. So there may be a problem there, but there may not. The problem also may be solvable in a whole number of ways, by the way, just in case it is a problem. The problem may be solvable in a whole number of ways. The worst possible solution would be, you're disqualified from asking questions to Barnhart, right? And even the law firm is disqualified. And the solution there is pretty self-evident, right? You create what used to be called, and I don't know if the rules allow for this in Washington or if they call it something different, but the way you used to solve this was by creating what you used to call Chinese wall, which maybe is called something different now because, of our times. But yeah, basically you get another attorney who has no familiarity and you get them to ask the questions, right? So you can hire somebody, or you can either do it directly or you get the client to hire someone for that limited purpose, and you don't give them any information other than what they would be able to discover on their own. So maybe that's the solution to the problem at the most extreme. So maybe. It seems a little unlikely that the remedy here is to completely disqualify him completely from the case. It seems a bit unlikely as a remedy. Because, Barnhart, for whatever value she has, is comparatively minimal, especially on the merits. Unless, again, and this is the big caveat to all this, unless, again, Katie Joy Paulson said a whole bunch of incriminating things to Lorianne. If Katie Joy said a whole bunch of incriminating things to Lorianne, her value goes up dramatically. And so the analysis changed dramatically. So it depends. Does she have a whole bunch of incriminating evidence in her back pocket? If the answer to that question is no, Lorianne Barnhart's value is jurisdictional, and there's no value on the merits. There's no reason to cross-examine her, because by the time it would come up, it would only be in discovery, at which point you've already reached the jurisdictional issue anyway, and so there's no point. She has nothing of value to offer past jurisdiction. If Katie Joy Paulson said a whole bunch of incriminating things in writing, emails, DMs, on the phone, whatever, to Lorianne, her value goes up immensely. The nature of the conflict grows, and Brown's ability to be involved may become of diminished reality, depending. So I guess we'll find out if we ever get to the jurisdiction issue. Further, if Barnhart testifies at trial on any facts not favorable to defendants to represent Paulson to the best of his ability, Brown must attempt to discredit it, which may be possible based on non-privileged testimony, so it might not be an issue, or blah, 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 whatever. We can deal with all that later. That is, again, in defendant's best interest for Brown to try to create doubt as to whether Barnhart is competent to testify and or convince a jury. I doubt that will happen. Unless that she is committed perjury when she testified. Accusing a former client of either incompetence or a crime to benefit another client could not be clear conflict. It's a conflict of interest for Brown Yeah. Therefore, Brown and his firm cannot exercise a duty of loyalty and to both Paulson and Barnhart. Maybe, possibly, depending on a whole host of things, depending on what exactly Miss Barnhart might testify to, if we ever get that far. For the foregoing reasons, plaintiffs respectfully request the court deny motion to qualify. Well, that was a whole lot of stuff. And yeah, that's the end of this. And there was, I think, only one more question. Totally unrelated question. If Brown quit and KJ called you to rep her, would you? I need a whole big pile of money in advance. Big pile of money. And I'm going to need to get Pro Hoc Vice. And I don't know, man. I don't know. Not for the least of reasons, because Brown would have put me in an inevitable, in a not desirable position here, based on his filings. His motion dismissed left a lot to be desired. So that's not great. So I have to figure out a way to dig out of this hole, which puts me in a very negative position. So there's things there. So yeah, I'm not sure about that one, but I'm not sure that's a really good idea. Yeah. Oh, I just wanted to make an announcement. I have 2 little shorts related to the last video for this that I did on the series, but I'm going to do those shorts on Instagram. I'm going to talk about the issues relating to my previous disagreement with Nate the lawyer, which I believe we've resolved, and I'd like to talk about it in a little bit more depth, and I'm also going to talk a little bit more about bias. And I think that might be interesting because, as I'm sure you guys noted, in the last video I posted or pinned something about bias, and there were some interesting comments there that I thought warranted some discussion, but I'm going to do that on Instagram. So my Instagram logo has been on the screen this whole time, so you can go subscribe over there, and we will do some shorts about that as time warrants. And there were 2 other questions from Maria. Is there anything Saltz can get the court to do to finally decide on jurisdiction? Yeah, I mean, Saltz could basically file a motion that says, can we just get to the core issue, and can you please tell everyone to shut up? So Saltz can file the can you STFU motion, and that would be good. Yeah, there's things he could do if he were so inclined. I'm not sure what his motivations are. Maybe he's not motivated by it because, he's getting paid for everything he's doing, so maybe he doesn't really care. Maybe Toddy doesn't really care. I don't know about his relationship with Toddy or what their strategy is. I wouldn't presume to speak to that, but yeah, there's things that he could do, can we just ignore everything? He could file the motion of, can we ignore everything and just decide on the jurisdiction now? That'd be good. And Michelle Roberts says, question, perhaps going pear-shaped. Do you think Brown's filings will diminish his standing in the legal community? Well, I couldn't really speak to that intelligently because I don't really know about his standing or reputation in the legal community. Based on his bio, it looks really good. And so I don't know what his general reputation is, but I will say this because, I don't know other things other than this one context. And so all I can really judge the man on is this one context, which might be unfair depending on other things that people know about him generally. So I can really only judge him on the one context. And the one thing that is notable in this one context, at least with respect to Brown, is that Brown seems to go to the worst possible interpretations of reality. It's everything he says is plausible, but it's like the worst possible case. He doesn't seem to give anyone any slack, including the other attorneys. He doesn't seem to credit them at all. And he's very aggressive in ways that I find to be unprofessional. Because you can be aggressive about the case. In fact, you should be. You should be zealous about the case. But that doesn't mean that you have to be antagonistic towards the other side or the other attorneys. That's not what that means. You should and must zealously represent your client's cause. That does not require you to be a dick to the other side. Nor should it. Nor do I think it's helpful, incidentally. I think being a dick to the other side is actually contra to the goal of zealous representation, because I think, in my opinion, that having a generally good relationship, at least professional, if not friendly, and I think there's nothing wrong with having a friendly relationship with the opposing side, but I think it's beneficial to your client to have at least a professional relationship, if not friendly, because it makes things smoother. You know, it means I don't have to drag every last thing out of the opposing side. You know, I don't have to fight tooth and nail. And if I need something like a favor, like I need a date moved, they're more likely to give it to me because we have a generally nice relationship. So I think, in my opinion, that having a completely antagonistic relationship with the other attorney is not good. It's also not good for the attorney's mental health usually, because when you're in an antagonistic relationship with the other attorney, then you're just asking for multiple years of pain. That's not necessary. So I don't think it's necessary, nor do I think it's advisable. So that's my one big criticism of Brown, is that he is seemingly deliberately antagonizing the other side for reasons that pass my understanding. And also, of course, the motion to dismiss, which was a train wreck, but we covered that long ago. So that's all I have for tonight. If you're enjoying this legal education content, for the 532 of you who are currently watching, thank you. If you're enjoying this legal education content, please remember to like the video. If you're not subscribed already, please hit the subscribe button. We produce lots of good content. We're going to have lots of good content coming up soon. We're going to deal with that, the wedding designer case. I think her last name is Page, with the contract issues. She sold her name and sold her business to the mean, evil company that wants to prevent her from designing wedding dresses ever again. I think her last name is Page. We're going to discuss that at some point. Tonight's original plan for streaming was we were going to discuss the George Floyd, Derek Chauvin decision to reinstate third-degree murder, because I thought that was bizarre, and we were going to try to figure out what was going on with that, but that didn't happen. So, yeah. There was a question from Melissa Boomer of the Night. So for $25, you'll cover a criminal case. Well, the problem with a trial-level criminal case is there's usually not an opinion, right? So what I say is for $25, I'll discuss any final opinion issued by a court, and usually, almost always, well, the only time that there's an opinion written by a criminal court at the trial level is if the trial court themselves is the judge and jury. So if they're the finder of fact, so then usually you'll get an opinion from the judge as to the finder of fact. So they'll write an opinion. Otherwise, there's usually not an opinion. There's just a judgment of guilty. So there's nothing to analyze. But yeah, courts of appeals are fine because there's lots to analyze there. So if it's a trial by the bench, if it's a bench trial, then yes, on the trial level, that's fine because there's something for me to discuss. Otherwise, courts of appeal, because otherwise there's nothing for me to discuss. So I hope all is well. Until later, my friends, cheers and goodbye.